Maybe it should be closer down by Nikki.
D?
Got your chair.
That's what I said.
Scoot around.
Yeah, I'll slide down.
Here,
Well, just
I
because
can just get up and move.
because Nikki and I are probably the most familiar. Oh, yeah, I guess that works. So we can straight. I think Nikki and I are probably most familiar with a lot of the edits.
Well, I know that I proposed that. I was told it was not necessary.
He did.
You were right.
Mm-hmm.
How are you?
Good, how are you?
Good. Feels so empty here today, and we're only missing like 2 people.
Oh, that's right. Chris is on the coast with Morgan, right?
Oh yeah, Morgan's here.
Yeah, they're on vacation together.
Yeah.
Well, but we have you in replace, I guess. I was thinking like we're just
Marisha's
down
over there too?
2 bodies.
Does Chris go out there and camp? Does he have like a, oh, okay.
Yeah,
Can you take the camper?
camper over there.
It's HENRIKSON.
Close, SEN.
I knew that.
SEN.
Yeah, it's all right. It's been misspelled since before I was ever born, so.
I was pretty sure there wasn't a C though, so I got that part right?
Yeah, I've seen HENDRIXSON.
Yeah,
before.
someone says Hendrickson. Sure.
Yeah, there are other Hendricksons around. but There's very few of my last names. I actually still have family in Denmark.
I'm gonna say 6
Oh.
sounds. Yeah.
Yeah. Where my family comes from, at least on my dad's side.
Nice.
I'm only 3rd generation here.
Really? That's interesting.
Oh.
Have you ever been over there?
I have not been to
Dude,
Denmark. I
people.
would like to go. My dad went.
Break my tooth more, did I?
Some second or third cousins, you know, whatever they over there.
So
Yeah.
is Jennifer gonna run the meeting?
Yeah, I think so.
For our side for the mayor.
Are you running the meeting?
Yeah, yeah.
Okay.
I did the council one.
Well, I'm ready when.
Council president. We call the meeting to order at 1:05 p.m.
There is a citizen comment.
Do we have any citizen comments from the members of the public?
The city hall ghost had something to say.
Oh, gosh.
There's some courthouses that believe they have ghosts. When I'm here by myself, it feels like someone's watching me.
You hear things.
Well, then
I
we'll
almost feel like.
I feel like there's someone downstairs
Mhm.
that doesn't.
We had an employee that I actually found huddled in the office in the break room, shivering,
Cause I saw a ghosty.
didn't know in the middle of the night because he thought people were trying to bring, I don't know how many times he called the cops when he'd work nights. What it was in the summertime when it starts cooling down, that metal building pops and snaps and everything.
Oh.
Oh, yeah, he was,
Yeah.
they finally told him to quit calling. You know, but yeah, we finally told him, well, quit coming in,
Right.
wait till somebody else is there, you know.
Oh.
But it does, it snaps and crackles and sounds like somebody's running into it at times.
Should we just go through article by article and with our new update? Our new proposals, would that be easiest?
probably would, if that's okay with them.
You want me to?
Before you do that, Chris had mentioned he was gonna bring the comparisons last time. Did any of you guys do that?
I grabbed what he
beforehand?
had, and I was looking through it and it's a little bit,
My understanding was you just wanted the names of the cities that had the overtime, the hours worked. And then he told you the names in that meeting.
Well, I wanted the information that he said that he had that, but I said for the purpose of that, I could just take the names. Cause we did take the names and we looked through, their policies and we didn't see anything that actually showed that they paid 3 times the rates on holidays, so trying to compare that to what he had.
Yeah,
to
I've
make
got,
sure
I've
that-
got it, I got what I could find, what I thought might be useful.
To make sure that we were looking at the same things.
So I guess we'll bring that up when we get to that article. I don't know. Or do you want to talk about it now?
Well, I mean, I was just hoping to get those comparables that he had said that he had compiled.
I mean, I only have one copy. Do you want to make a copy or do you want me to tell you what it says or have you read it and copy down?
Let me just take a look at it.
Not mine,
See if-
sorry, I just grabbed Chris's
See if
stuff.
it's the same thing, because he was saying their policy provided for,
It'd be highlighted. I don't know what he had highlighted.
um. Yes. But, I mean, I didn't. So this looks like a City of Post Falls IUOE contract 22 to 24.
What it looked like to me. Like I said, I just opened up his files today and started looking through what he had. Cause you guys had asked for it before and I thought he had it with him, but maybe he was just flustered. I don't know.
I think it was a misunderstanding, cause it was, I understood that too, you wanted the names, so I.
So here's Walla Walla. Made a couple, that one, and then here is Coeur d'Alene. That one I didn't make any notes on, but there's some highlighted stuff on there.
Jennifer, if you don't mind running the copies of anything, let me know.
For the most part, most of this, so I'm just noting that using the names that we had, other than Post Falls, we didn't see any of them that were paying 3 times the rate, like you said, that they all were. There's varying rates that they're paying, but none of them are actually 3 times. And some of them pay, a premium in lieu of receiving holiday pay. Or they have there's a couple of different schemes that they have. We couldn't find anything to actually show that any of them received 3 times the rate, like he said that they all were receiving.
Just for the record, I didn't say this because I didn't research this, but.
Well, yeah, I mean, I'm just saying that that's what he said.
I'll get the man, sorry, I got the man stuff here because I don't know exactly. What I found that he highlighted was time and a half on holidays work seemed to be a consistency. Running through with his paperwork that he had. So overtime.
Oh, this is Hello.
Oh, that's for Shell, sorry. Okay, yeah, Poco, that would be. It's also. For figuring overtime. He might have some more stuff in here, that's pretty fun.
Questions if I get to elaborate on these. Just like. Fine.
Well, do you want us to just work through the red line we sent you this morning?
Yeah, I thought that's what
Yes.
we're doing.
Okay, sorry, no, I was just making sure everyone's ready to move on.
I think.
Yes. Okay. So I don't think our most recent red line changed anything to the preamble or Article 1. I mean, there are still little changes that I don't know that if you guys agree or not, like we marked out asset management technician, cross connection specialist, environmental program assistants, and those are positions we don't have anymore. We may need to change this to Article 3. New to Article 4. 5. No changes from what we originally proposed to Article 6. Struck a lot of the binding language. No changes to Article 7. 8.
So back to Article 6 under grievances, is the still city, just to clarify, asking that the mayor's the final say for grievances?
Yeah, I mean, I believe that's still like proposal.
Yeah, to strike mediation and arbitration. How would that work if the city has a right to file a grievance against the union? And the mayor's the final say, that kind of feels like a conflict there, if the mayor's the final say when the city files a grievance.
So the changes that were proposed does state it does not include disputes between the union and the city concerning the collective bargaining agreement itself and or matters related to the contract negotiations, so. Not sure if that concern would arise under this policy.
But if you go up to Article 4, it says, failure of the union to comply with the above provisions of the city's initiation shall be subject to a grievance by management.
We could strike that then. From section 4 to comply with section 6, that provides a grievance represents a disagreement between the employees and the city, not between the union and the city, regarding interpretation, application, or alleged violation of this agreement.
That's all the questions I have.
Yeah, where are you at?
Definition under Article 6. Oh,
Okay.
Go up to 4.
he was on 4.
Article 4.
And then.
Down. Here. Get rid of the
Yep.
whole sentence. Go back into suggesting. Oh, hang on. Apparently not.
Mhm.
Oh.
Okay, failure of the union to comply with the above provisions, blah, 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 delete. Okay. Okay, so I don't think we made any changes, right, maybe to 7. Or 8.
Actually, so I'm looking at section 1 of Article 6. It does provide disputes or differences arising between the city and the union shall be settled in the following manner. But it,
Oh, that's right.
so we need to make some provisions there. That's a page.
But if you want to strike that out, then how would we resolve those issues?
Well, we can leave that language and just have a grievance procedure that's specific between the city and the union that doesn't involve any, arbitration or expedited mediation, as it was previously set out. My understanding is that the intent was to address disputes between the employees and the city, and not necessarily disputes between the city and the union itself. Wherein, you know, it's the union and the city.
And just to clarify that, so a grievance is owned by the union.
So it's a dispute between the employee and between the employee and the city. And then the union can represent the employee or provide representation for the employee. But, I mean, I don't understand why it's owned by the union.
Cause
Can you
the
explain?
union, after step one, the union body is in charge of how that grievance would proceed up through the steps.
Can you explain that further?
So most grievances filed with the immediate supervisor and informal discussion. After that step, the grievance is then owned by the union, and the union body decides whether or not to move it up through the steps to keep that grievance going or not. Which is just the internal process of the union.
That might be the union, but that's not necessarily between the city or the employee and the city. I mean, I'm just not seeing that here in this process that's been set out that you're mentioning. So your internal workings might have something different, but again, this is related to the employee and the city. So I mean, I don't see any language that you proposed that outlines that. That might be how you.
Because we don't necessarily agree to having the mayor do the final say for the grievance, so no, that language has not been proposed by our side.
Yeah, so if you don't agree, what language are you proposing alternatively? Or is your disagreement that, you don't agree to what we proposed and you wanna keep the old language?
That's what's been in our proposals, to keep the old language. We have not agreed to the city's language at this point in time.
Okay. So have you made a written proposal related to what? Well, I'll just look at what you provided, let's see. So the last proposal I have was dated June 10th. That was right.
No, there's one from 6/12.
I think it was sent on 6/12, but it was dated to then.
You had both of those printed out, right? One had 6/10 and one had 6/12 on it, correct?
Yeah, the one from 6/12 does say 6/12. There's probably no changes though between your proposals in that article.
Oh yeah, they're both six. You want a copy?
No, no.
Okay.
I just pulling up the file, because I didn't print but one of them. I wanna make sure.
This is 6/12, Jennifer, do you need it?
Yeah, I was never sent that document. I don't know why I was also not included in it, the email. I think I'm gonna forward it to you. I have a 6/10 that you forwarded to me.
Oh. Did I forward it to you?
I don't have any other emails from June 12th from anyone.
Okay, I'll forward it to you now. Okay.
He's got the hard copy. Okay.
So your proposal is just to keep the article as is.
As is, current contract language. which from 6:10 to 6:12, that one, if I remember correctly, didn't make, there was no changes to that. It was just the changes to like the discipline and clarifying the holiday callback overtime items.
So in rejecting the city's proposed language, you have no alternatives or no other terms that you wish to propose in lieu of what the city's proposed?
At this time, we are our point until we have another proposal or can caucus and discuss it as a group. It's current contract language is what we're proposing.
You realize we only have one more scheduled meeting
We do.
for this, that have we changed this grievance proposal language since we first initiated this? Have we made any other proposals, changes to it?
No, I mean, we've kept the grievance procedure, how we modified it since the beginning. We didn't make any changes.
Yeah, I don't think we've updated it since our first
Mhm.
proposal.
And there's been no discussion on that on your side that you're
We've-
able to.
We've discussed with the city that our intention is to not have grievances resolved with the mayor. We do not want
Mhm.
to have him as the final say. We want a mediator and arbitrator as the current contract reads. So we want to keep the language as is.
Okay. And if we are not, if the city is unwilling to keep it as is, are you willing to propose alternative language for the next meeting?
We will definitely look at that as a whole package for our proposal if we have another one for the next meeting.
Okay, I'm just trying to figure out, is this a term that you're willing to negotiate and will propose alternative language in response to what the city has provided? Or it's a matter that's not currently up for negotiation?
So are you talking about the whole article or just that if who the final say of a grievance is?
Well, the city proposed revisions to the whole article. I understand that your position is that you're not willing to accept those changes. So taking what the city has proposed in consideration, is there an alternative to proposal from you all as far as what would be acceptable, taking in consideration of what the city's proposal is?
At this point, no, because we do not want grievances to end with the mayor.
But you don't know who, or an alternative means, or you haven't discussed an alternative means in lieu of the exact procedure that's currently proposed that the city wishes to change. You're not proposing something else that is a compromise or anything like
I
that.
guess what's wrong with having a list of arbitrators to pick from or mediators?
Well, I can tell you that, as far as the city has been concerned, having the FMCS, which I believe that's what this provided for our camera. Yeah, the FMCS, the Federal Mediation and Conciliation Service, that department is currently reduced by 95% through Doge. And so it's not currently funded as a federal department and is in the process of operating on a very basic framework. So whether or not that department will even exist in the next 3 years is questionable. We've already worked through them recently, and the cost of using Federal Mediation and Conciliation Service is quite high. And so, taking that into concern or in consideration, the city wants to not have to follow a process that is very costly, both on the side of the city using taxpayer dollars and the side of the union, because, your resources are limited. As far as we're aware, each side that's getting funding. So we're trying to find more cost-effective and faster means. And going through this particular process hasn't been a cost effective or timely means to resolve matters.
We'll take that into consideration.
Right, we wanna move on?
Yes.
Okay. So no new changes to Article 7, but there were original proposed changes. Which would mostly the at will. Language, I believe. Nothing to Article 8 except some small grammar. Changes. Article 9. Nothing new, just the same. Things we discussed about seniority. We did add to Section 7, item D, just a little bit of language to clarify those transfers that we talked about. So now it reads, neither city nor department seniority shall be lost when an employee is transferred from one department to another due to the needs of the city. So just to kind of clarify that item. And then, of course, we added the disciplinary transfers as item F. Article 10, just some more clarifying language, nothing new.
Sorry, Liz, can we back up? I'm sorry.
Yeah,
Let me go back to the transfers. I'm just trying to compare the two here too. So. In the 610 or 610. Proposal. We have involuntary transfers.
yeah, we
Did we
changed
change that?
that to
disciplinary?
disciplinary,
Fair enough,
Yeah.
okay,
because that's really what they are.
Correct,
Right?
correct, yes. Well, we did talk about being disciplined versus the city moving you.
Right, and so that's why we added that language to the
Fair
other one.
That's what I thought you were saying, okay.
Okay, yeah, Article 10, just some of that clarifying language, nothing new on this proposal.
But we added language that they wanted, right?
Yeah. Article 11. Okay, so we reworked some of the overtime language. However, our intent, I believe, I guess would stay the same. The overtime is only earned after 40 hours worked. So I'll let you guys read that for a minute. Let me know if you have any questions. Any questions about that language?
You have.
Well, I just said these are the things that like overtime, call it on holiday. I didn't provide like a description summary.
I think it's just that.
Move on.
Yep.
Okay. No other new changes until call out pay. And then we did try to clarify call out a little bit, so I believe we made some edits to that language. But again, our intent stayed the same, that call out is 1.5. We reference call out on holidays later, just so you know, this is not including holiday call outs.
And the hours actually worked on a call out, you don't want to go towards the overtime calculation.
Correct, because it's already paid at the same rate as overtime. It's already paid at time and a half. And then eliminating that doubling up on those 2-hour minimums too. So any questions about section 3? Good to move on. Good. No new changes to section 4. 5 or 6, 7. 8, 9. Okay. And then Article 12 holidays. In section 1, it's just that same language about part-time employees. And requesting their floating holiday, that's all the same. Okay, and then section 2, working on holidays. So obviously we know these would need to be re-lettered. B would become A, C would be B. We'll do that at the end. But we tried to rewrite these to clarify a little bit, and then we did adjust our proposal's intent. So B is the same, you would get the holiday or take another day off that week. And then in item C, we have adjusted it a little bit. So most city holidays will still be what we consider essentially 2 times your rate. So you get your holiday pay if you work on the holiday, and then straight time for your hours worked. However, we do recognize that the plants operate on Thanksgiving and Christmas Day, I believe. So we are willing to pay what we consider triple time for those scheduled to work on those 2 holidays, on Thanksgiving Day and Christmas Day. So you would get twice your regular rate of pay for hours worked, plus holiday pay for your standard work day, or for the holiday for your standard work day. Any questions about that item? No. Our understanding that those are the only 2 groups that are scheduled typically on those days. Is that correct? Or-
Yes.
Technically, you're correct.
Okay. Okay, and then item D, we adjusted some of the language for call out on city recognized holiday. So you would still get your holiday pay for your standard work day. Okay, whatever your standard work day is, if it's 10, if it's 8, you'd still get that. And then if you are called out anytime on that day, then for those hours, you would get 2 times your regular rate. Does that make sense?
Yes.
We tried to make it as clear and simple as possible. So we have adjusted our proposal for that.
And then this is not agreeing to have that higher premium for a call out on a Sunday.
Correct. We are remaining the same on our original proposal. There's no premium or additional pays for Sundays. And then we just added item E so that you could reference back to Article 11. Abuse of holiday sections.
No, D didn't show up on mine. That's all right.
No changes to section 3 since our original proposal, but it does include that language that the absence has to be approved by has to be covered by approved accrued leave. I just want to make sure you guys saw that language, because I don't think I saw it incorporated into your red line.
No, approved sick leave is pre-notification, not calling it.
Yeah, I think we just put it
Yeah.
as approved leave, or I can't.
Yeah.
Or if you're
Yeah.
on approved bereavement leave or approved vacation or Yeah, or if you're on FMLA or something like that, yeah.
Right, I think, no problem.
Okay, we agreed to leave vacation in. No changes.
Just note too, that if the city were to ever update their vacation policies, it would not apply to your work.
That is understood.
We agree to leave Article 14 sick leave in. No changes.
Same thing, if the city updates sick leave policies, it would not apply to your work.
The group understands that.
I believe you guys were in agreement to take out the workers' compensation. Article. That is still stricken?
Yes.
Okay, struck. Stricken. Okay, and then same with Article 16, family medical leave. So I'm gonna Google Doc on my computer and there's no good way to like scroll quickly. Little by little, here I go. And this is a long one. Okay, we still have bereavement stricken.
Oh, yeah, I think we didn't need to do that.
Yeah, I think we're okay leaving bereavement in.
Okay.
So I will unstrike.
What article was that?
Article
17.
17.
I don't think we have it in here since we wanted to take it out. So we can, I assume we're fine adding it in.
I mean,
Is
that's
it
how
right
it's
here?
currently being done.
I think that's what.
Yeah.
Was that with the change of the
That's
first
what we're talking
part?
about right now. I think they-
Yeah, we're okay
That
keeping
change.
that change that you guys wanted in there. I
Okay.
just wanted to make sure I have it exactly how you guys have. So let me find it on your red line. Okay, so after working days, leave. Okay, so yeah, we are fine with that. Article 18, safety, we were in agreement about increasing the boot allowance. We are still talking to our benefits administrator about safety glasses, just so you guys know.
Okay.
Article 19, you guys agreed to remove, which is just the military leave. Article 20, no changes. Article 21, no changes. Article 22, is that what changes is 22? We added so we took out all of section 1, so that no longer applies. Yeah, so we'll renumber those. But under the current section 2, which would become the new section 1, we added for October 1, 2025, the 1% market adjustment to the 2.5% COLA language. Otherwise, I don't think anything else is new. Not. No changes to 23, 24, except for updating dates. Nothing to 25, 26. 27, just for removing some excessive language. Article 28, you guys agreed to remove the drug free workplace policy. Nothing to 29, Article 29, and then for the Article 30 disciplines. We added language that would allow for union members to request after 24 months to remove record of discussions from their employee file with department director approval. As long as there are no additional infractions,
Related,
related infractions.
is that the? Cause I remember there was like two in the first.
You guys,
Start.
well, you guys had asked that record of discussion and official reprimands be able to be removed.
Okay,
We're not agreeing to official reprimands, but we are agreeing to records of discussion.
okay.
And that's it.
You guys want to caucus and discuss?
Yes. Yeah.
Okay, we will caucus at 1:30 or 1:42.
And nursing,
Yeah,
why
get-
you, yeah.
Okay, it's 3 o'clock and we are back in the caucus.
You guys were in there for a while.
So I did email over a proposal. Did that go through yet?
I don't have one yet.
What'd you do carrying my bag?
You complain about how heavy it was.
He's druggish.
Okay.
It made it from point A to point B, that's all I can tell you.
Then like the airport luggage.
Um,
Throw it, walk up, grab it, throw it.
Do you wanna try connecting to the city's gas internet?
It's in my house.
Anybody else on it?
No, it's in my outbox, but I don't know why it's there. I thought there was a button to like release all. I'm having technical difficulties. Apologize.
So while you're working on that, I just wanted to let you know, I looked at the documents that you had provided. There's one that's called PF IUOE Contract 2022 to 2024, which you guys said was from Post Falls. That's actually, the city of Post Falls does not negotiate with any labor unions, so that's not a Post Falls union contract. So, when I looked through, I think it's actually a city of Kennewick document. And so that'd be Kennewick, Washington. But I did reach out to their city attorney to see if they have any, if they recognize the IUOE as one of their city labor unions that they negotiate with, but they do not.
So it was not postponed.
No, it's not Post Falls. That's their pay scale, but that document is not a.
Okay, fair enough. Like I said, I don't know. This is just Chris handed me the file. He said my stuff's in there. So,
So good luck.
yeah, essentially.
Thanks, Chris.
Yeah,
Just gonna redo my email, so bear with me for a minute. You love technology when it works. Okay. Well, they'll probably be fine with that. This is not related to you guys. It's good to know. Just looks like- Laura, I think you should try connecting to the city's internet. See if that helps.
Okay,
I think that's what they're.
says it's sending.
Because we do have a City of Lewiston guest.
AT&T not work too great over here.
No,
I don't know. I don't know.
no, my mother-in-law, she had to put in this like big LT or single booster on their house, or my father-in-law did, because she's like. She's got a stomach
try to get
issue
AT&T?
that she has to get surgery on, but if it goes wrong within.
No, I
24
tried
hours,
to
she
get
has
Verizon.
somewhere.
Or not Verizon, sorry, T-Mobile.
T-Mobile.
I used to have
And they were
AT&T,
just starting
and
it.
it worked just
They're
fine
not
with
a lot
that,
of-
maybe 5 years
It's
ago,
way cheaper.
maybe longer. Time goes so quick.
Great results with Verizon, so.
I like Verizon.
I have no idea.
Yeah.
They're- With their coverage.
Change it while it's sending. Maybe because I closed it before it hit send. I'll look away at work. Everybody's staring at me.
We are now.
Thanks. Did you lose the guess?
Yeah, and then the password when you're ready, I'll tell you.
Oh,
You really gonna say it?
Oh, we're
Oh.
recording.
Well, it's our guest one.
That's true.
I don't think it's a public guest one though.
Mm-hmm.
Okay,
You
well,
wanna write it?
I'll whisper it to you.
Just write it down.
No, I like the whisper. Morse coded over there.
Yeah, Morse code it. I would be able to read it anyways.
Okay, those are all numbers.
So that,
All numbers, okay.
Yeah.
yeah, yeah. They're just well phased out
Next
by
thing, yes.
time.
Yeah.
Thanks, Brett.
Oh, yeah.
Very
Otherwise,
good
you
job.
think, like, they still had to learn it if that was your job, but it was only as like
I think every
a absolute
every
backup.
submarine.
Look up the watch.
See, it's supposed to be like really cool on Saturday, like rain.
The high of McCall is supposed to be 48 on Saturday. And,
Salt the
and
moon.
snow advisory for Saturday.
Awesome.
Really?
Only McCall.
Yeah, I booked my daughter's birthday party at the aquatic center for Saturday.
Oh, outside? Oh, that's not good.
So.
We'll be inside.
We'll be
Is there a hot
inside.
tub?
Isn't it heated outside still though? Like not heated like the inside, but still I thought they did
The water. I don't
some
know.
heating for it outside.
Yeah, the kids.
They don't even heat the inside that much.
Yeah, like it hears the kids warming up for you.
Ew.
I'm a realist.
Clearly.
For probably some of the adults too, if we're being
Yeah,
honest.
yeah.
Like grown-ups. With the
Yeah.
blue dye.
One just went through.
Ew.
We were at Three Rivers.
Yeah.
Let's see if it comes through your
We were at
side.
Three Rivers 2 weekends ago.
It was super
I mean,
refreshing.
it was hot up there, but the pool's still cold. My kids swam in it for 12 hours the whole time.
Yeah.
I was like.
Kids are
"How do you kids
crazy."
do this?"
My kids
Yeah.
swam in the ocean at Lincoln City on spring break one year.
Oh, yeah,
Yeah.
that's gotta be cold.
Okay, I got it.
I was young once. But
That was like
Yeah, well.
trying to convince you you
I
get
was
to go.
young so long ago, I can't remember what it doesn't feel like to.
Go
my
swimming.
ankles barely get in the Oregon coast.
Our family boated every Easter Sunday, regardless of the weather. This is in Wyoming. And my mom's thing was,
You got in the
okay,
water?
who's water skiing first? And you water skied. And I remember saying, if there's snow right there in the mountains, Mom, and she's like, well, don't fall down. And that was it. I water skied around the island.
Did
and
you
that was
just go
it.
from dock back to dock?
Oh, yeah, we didn't, we just like got over by the beach and fell in the water and.
Yeah, Christine said she wanted to take the boat out Saturday until she checked the weather. She said, never.
I'm a
Yeah,
fair
I
weather
checked it
boater.
last
because
week.
of
It
how
was rain at home for us, so it must still be pretty nasty for Saturday.
All right, does everyone have it pulled up?
Yeah.
Okay, we're ready.
All right, so.
Amy doesn't.
I was.
You want me to wait a
Look at the weather. Calling her out.
No, I'm like working on my presentation. I'm kind of on a short timeline here.
Do you guys want to do what we did? Just go through kind of.
Well, pretty much we went through it and we identified 4 articles that are basically still in discussion on. Everything else is agreed upon. Was Article 6, the grievance, Article 11, the workday, Article 12, holidays, and Article 30. So we only made changes to those 4 articles.
Okay, so 6, 11, 12, and 30.
Yes. So for the grievance. We added back in section 1D. With the change to that instead of an arbitrator, mediator, that we would like it to be a board of 3 council members. Drawn randomly to see who that board would be to hear that grievance as the final result of it.
I'm gonna tell you, that's gonna be a violation of the open meeting laws unless you want that to be public. Potentially, because there are situations where in executive session, they can discuss certain employee things, but not in the manner that you're describing. Okay.
So our reasoning for that was to try to, who could be that person or board to review that without having cause a financial impact on the city. So was our thought on that, but we can discuss further.
Or is it something we
But
could
you could do
designate
like-
as an executive session at that? point?
Well,
That day.
2 city council members and another body of some kind.
Well, under executive session laws, the only reason for which the city council can go into executive session that applies is under Idaho Code 74-206, subsection 1. And 1A or 1B, and these laws are intended to be narrowly construed. And as far as it comes down to essentially discipline, so subsection 1B states to consider the evaluation, dismissal, or disciplining of, or to hear complaints or charges brought against a public officer, employee, staff member, individual agent, or public school student. There's not anything, so they wouldn't be able to consider anything other than that. And so a grievance is not discipline, it's not dismissal, it's not evaluation, and it's not charges against potentially. Okay, so under Idaho law, the council members wouldn't be able to be involved in that, in the manner that you.
Question on that, is that any council members or anyone above like a single?
Typically, it's anything in which they would potentially be deliberating about, so, once you have 2 or more board or city council members, you have, there's a possibility of deliberation, but once you get 3 or more, then you have the possibility of a meeting.
Well, I guess what my question is, if we had one council member and say one other, person that is not a council member,
I think you're saying we
would
could
that
have
still
2.
fall under the same thing for that council member?
Only if the matter eventually comes before the city council as a whole, there could be a potential issue. But it does not, once you take away the 3. So.
Some 3 or less is what you're.
No, 2 or less.
2 or less.
It
2 or
probably
less,
have to
sorry.
be 2 or less.
2 or less.
So 2 and a designated. I don't think that's undoable.
I guess because in discussion, we felt like having the whole, and I don't know how this applies to the open meeting, but if it's all 6 and done as an executive session, could it be done that way?
Well, again,
But
in executive session, it's
Has
only
to be.
limited to those
Right.
matters.
Yeah.
Right,
Yeah, you can only use
Otherwise,
executive session for certain things.
Right,
O-
right.
Otherwise, it'd be a public matter if you involve the council.
Gotcha.
And I don't know if the employee would want their grievance to be a public matter.
Yeah, at a council meeting.
Yeah,
At a recorded council meeting,
so 2 and 1 other person, not a council member though.
that potentially would work.
Okay.
And the mayor would have to count for, if he was one of them, he'd be one of the two council, right? He doesn't-
No, he's not, technically, he's not a voting member, so
Right.
he doesn't count for that. And he gets the option to vote in ties. And so, if he doesn't vote in the tie, which he has the option to choose not to, he doesn't fall into that.
So without
So-
caucusing, sorry, this is more of a discussion, but you're, without caucusing about this. I think our goal was never to have one person determine something that involves other people or other groups, even one person saying the final say. More of having a representative body or at least a team. If the mayor's goal is to be the final say, if the mayor, along with two randomly drawn council members. Without caucusing, I think we could live with that.
Let's step out for a second. I have an idea.
Okay, thank
Sorry.
you, that's fine.
Just a
So
few
we'll call a
seconds.
caucus at 3:15.
Yeah.
We should do something like that to make things hurt, but they just hurt when I get up in the morning, so.
See you in 18 years.
Jennifer, we return from,
We returned at 3:17.
So we would like to alter that and say it will still be a board of three, which would include a city council member drawn at random. And then two community members, which the union would pick one and the city would pick a person to represent them on that committee.
Can you clarify by community members? Because again, under the public information laws, employee matters are confidential. And so if you involve the members of the public, then you're making that matter public.
Okay. Any ideas,
Because
guys?
they would owe no obligation
Go
to
ahead.
the city.
Wouldn't that be simply like the city would pick a city employee that they're comfortable with representing them? And we're comfortable with picking a city employee as well? And those two people would then be a part of that committee?
I would be fine with that if the
Does that
city
make
is.
sense?
Do you want to say what maybe we were thinking?
Sure.
yeah,
Yeah, I can say it.
yeah, go ahead.
So one of the things that we were thinking, is we could have a 3-board panel where, you have the HR director and then a person of your choice from either union representative or your union leadership. And then the third party could be potentially the city council member. That way it's kind of like a person, if you're choosing in your leadership, and for us, it would be our HR director and then a randomly chosen city council member.
I'm okay with that.
I'm fine with that.
Okay,
Mhm.
The goal is to get a group, so.
Yes.
Yes, I'm okay with
Oh my gosh, yay. Yay, us.
I know, my brain's going, one down.
Yeah.
We have a common goal, we just want to go back to our job.
But it looked like you guys took out the binding language, is that right still?
It wasn't in proposal because I used your proposal.
Oh,
Yeah, we struck it.
so that's good to go?
So, yes, I used the document you emailed over this morning to
Okay.
make our edits too.
So that part's in agree.
I believe we absolutely did. Did we want to make sure that language reads as mediation?
Well, it's as last step of the grievance and then there's no steps after that, so that, I interpret that as that's the last step.
So, okay, so we can take arbitration as just not
Yes.
part of the discussion. Okay,
Right.
okay.
Should we, Jennifer, should we be responsible for writing out that language as we feel like needs to be?
I mean, if they are comfortable with us doing that.
I think we all are under the same agreement on that, so.
Don't pull any fast one. We won't make it hard on you.
I don't want more trouble.
That's right, let's just, summer started now, let's get on,
I don't want more
right?
drama. Well,
I'll all else fails, fall back to hillbillies.
We're gonna spit in each other's hands and shit.
Y'all can be, y'all can be.
I don't think I wanna. Sorry, Pat, I'll step out of that.
Okay, so we're good on Article 6?
Y'all.
Yeah.
Because their teeth fell out at 20 and they couldn't eat it anymore.
Okay, so Article 11?
Yes.
Looks like yours is in red, is that right? Your changes?
Well,
It's the same.
all the color is,
Mine's not.
there's some green, there's some pink.
It looked like your changes on mine at least show up. in
Yeah,
red.
so for
They're
section
split.
2 for overtime, we do not want holiday or sick hours to be included in the overtime calculation. But we will include comp time and the holiday pay included, or am I saying this right? The holiday straight hours excluded from the overtime calculation.
Yes.
Like
And that makes sense to me.
Maybe restate it, Ryan, so I.
Comp times earn a time and a half, so that's not a fair comparison to calculating overtime. And then holiday hours are, everybody's getting paid that, most people are not working it, so that we feel doesn't need to be included toward a 40-hour work week. Vacation and sick, our thoughts are those are earned benefits, those aren't given. You have to earn those over time. You have to be careful with them or you can run out of either. So you're using a city earned benefit. And for the most part, vacations are pre-planned. It's easier to schedule around. Sick, we talked about pre-planned sickness. The problem is again, one of our sticklers is we do not want to encourage people to not use sick leave and show up for work sick. So
Okay.
sick is hard, but again, to me, sick is accountability. If you're out of sick leave, you're out of sick leave, and I mean, sometimes you're gonna need it and you wish you didn't use it when you did. Or you just had a really tough go of it and you just don't have any sick leave, but they're earned benefits. I don't think people, I should say, I know plenty of people abuse sick leave, but if they abuse it, they're gonna run out. So.
Do you mind if I just make a statement in response to that? I mean, if you have sick leave and vacation counting towards your hours, as part of your 40 hours worked, that would actually benefit your accrual balances, because if you do then work overtime in that week, the overtime would offset your accrued leave and you wouldn't end up using what you otherwise would have used.
Correct. Yes.
So really, it would benefit your accrual balances to not do that. Like if you are calling sick on a Monday and then you work Tuesday, Wednesday, Thursday, and then come in for overtime on Friday. Yes, technically your Friday wouldn't be considered overtime, but then you wouldn't be using any sick leave on Monday because it'd be a wash.
Some
So
people may
you're.
choose to do that, some people may not, right?
I totally
I
get
mean,
it.
so
I understand what
so
you're
I'm
saying.
just, I'm just saying, so the
No, and I get
argument
it.
that it would help your accruals is.
No,
Be
and
better
that's a
for your
legitimate
balances.
point, and I understand it. And, that's something we could try to tell the work group. But I know some people I've talked to, first talked about the 40-hour work week, and, the optics of it for us is we are, with this proposal, we're penalizing people to use vacation. Vacation is different a little bit. We're penalizing people to not call in sick. And I don't like that. I mean, that happens already anyhow, and in our little departments, it's a watchdog group. Somebody's sick, we're on them until they go home, or until they file a grievance, because we're giving them a hard time, because they usually are like, yeah, you're right, I shouldn't be here. You got those people who just feel like they have to be at work, and then you have those people who, well, I don't know, streets a little different, not ours, but okay, Friday's coming up, I have Friday off, but I know so-and-so are going on vacation and somebody's gonna ask me to work overtime. So I just don't want it to look like we're penalizing people for using their earned city benefits. I think comp time is an easy argument because that's earned a time and a half.
Mhm.
I don't think that's a fair comparison, so I don't think that needs to be counted. And holidays, you're getting paid for the holiday. Most people don't have an option to go to work on holiday. I mean, City Hall is locked up and closed.
Mhm.
People aren't gonna show up at the water plant just because, there's that one person's gonna be there who's scheduled.
Okay.
Anything else is a call. So I think that's, I'm kind of in agreement on that, that's our stance, okay. So that's why we proposed it that way.
Well, let's just get, yeah. let's just-
Then the rest of the call out, we didn't make any changes on.
It looks like you maybe just added some language.
Oh, yeah, sorry, I wasn't at the, all the way through the
Yeah,
page.
Doesn't really change the intent.
Yeah, it didn't change the intent, we just wanted to clarify that, if you were called out and it's 3 hours, that extra hour would also
still
be paid
a
at
time and a
time
half.
and a half. Yes.
And then we add in there, maybe it's in there, and I missed it, but we have a 2 hour window, right? We all agree that, 2 hour window. Once that 2 hours is done,
Mhm.
let's say you work 3, so you get a call out of 2, and then you get a call out of time and a half, right? Just extended call out, if you will. You go home for an hour, phone rings again, and you go back in, that second 2 window hour that starts.
That's a new one, yeah.
Okay, I know we're in agreement on that, I just
Yes.
didn't read it that way,
Mhm.
so I asked Laura, maybe we should put that in there, but yes, okay,
Yes.
we're fine.
I believe that's it for that article, but let me scroll, yes.
And
Then the next one was Article 12 for holidays. We made a change to what is Section C. Labeled Section C, instead of just those departments, we want it to specify any employees who are scheduled to work on Thanksgiving or Christmas would be paid at that rate, just in case some other department decides to schedule work on those days, which we know it has never really happened that we could think of. But just in case it does. I believe that was the last change we made to the proposal.
You guys-
Oh, no, sorry, Article 30, the
Oh, I was gonna say
discipline.
discipline.
I got ahead of, I thought.
Wait, can we go
Getting
back, sorry,
excited.
sorry, can we go back to the holiday?
Mhm.
Remember, we had that paragraph. The section E that was kind of out of, was there anything in there we wanted to change, or were we just signifying that was a different?
It just needed to be a new paragraph.
Yeah, on
Oh,
mine,
okay.
it wasn't paragraph
Okay,
over,
that's
like
fine.
this
Did
paragraph.
you guys see that? E was right here, we kind of lost track of when you guys were talking, but it's.
Oh, okay.
That,
Yeah, and we'll make sure, like, once we accept all the edits, that everything's,
Numbered appropriately and
Yeah.
lettered.
that's fine.
we don't worry too much
Hard to do it when
about,
it's-
we don't worry too much about those while we're negotiating, because they can change.
I'm not worried, we had a mark there, and I wanted to make sure we didn't want to have to talk about it.
No, I just made it a little paragraph. Make sure.
Alright.
Okay, so now down to 30,
Yeah.
down to the end.
I'm confused too.
Like you just added. a
We just
paragraph.
added a paragraph. Basically, we want that if the employees can request union representation to attend a meeting, which may lead to disciplinary or is disciplinary per their Weingarten rights. And then they are also entitled to a louder mill hearing before any discipline is issued other than the initial. You guys classified it as a, gosh, I just lost the word, official documentation or document.
Record of discussion.
Yes. And then that with employee consent, the union representatives shall have access to employees' records regarding discipline.
So to clarify your paragraph, your first sentence, so you only want union representation for any meeting that implicates Weingarten rights, so any investigatory interview, but not the disciplinary one themselves, or what?
Well, that's what No, if the employee requests union representation, we want to be able to represent them through that whole disciplinary process, which would. If it goes into official disciplinary, then we would want a louder mill hearing where that representation would continue, because that is disciplinary.
Well, you said Weingarten, not necessarily Loudermill is a different sentence.
Yes, so the intent with that, and I probably didn't write it very clearly because we were trying to rush and get it done back to you guys, but, our intent that is we want to be able to represent employees who may be going into disciplinary. And if a disciplinary is issued, then they have representation with the union in addition to a louder mill hearing
Okay,
before the official discipline is issued.
that's one of the changes that of being at will is that they wouldn't have the Loudermill hearing anymore. But the Weingarten one, that's different.
Yes, the Weingartner is a from the National Labor Board from the 1978 case where employees are entitled to union representation for any discipline meetings or meetings that could lead to disciplinary in the future.
Yeah, but Loudermill, so I'm just saying, you're asking for the same, you're asking for two different things, but so Weingarten, one thing. And that's typically for investigatory interviews. But Loudermill is more of like a name clearing hearing. And that's that's when termination is for cause. So as a part of its at will status, Loudermill hearings aren't provided anymore because you're not terminating for cause.
Okay,
'Cause
but
we're-
per the personnel policy under discipline, it references that you will have a option to present your case, your documentation evidence for that.
And I believe, we can clarify, but that's for those employees that are carrying over from the current union contracts for the
They're not.
That are
that are
not yet.
not at will.
Okay,
So,
but I
we can
thought you
have
kept
both.
referencing Idaho state law that says for a public employee, you have to give the employee an opportunity to present their information.
That's not Idaho statutes, that's just their constitutional rights.
Mhm.
So, but that's not Loudermill,
Okay,
so I'm just.
well, we can
trying to
rename it,
clarify.
a hearing will be held prior.
Well, I think
Okay.
we can discuss it.
Okay.
So just, and the reason why, again, I was clarifying is because one is more disciplinary and one is termination related. And this is your disciplinary section. So Weingarten is investigatory actions, whereas Loudermill is more termination based.
We just want to clarify and put in there that if the employee asks for union representation and they're covered under the contract, we can do that if they request it.
And I thought that we included that elsewhere in the contract.
I don't believe that's been in there because we've been talking about it and how to resolve that. So. You could point out where that is, that'd be helpful.
That's what I was looking.
You don't have anything that are there. This one?
Yeah.
Okay. This thing jumps around so bad.
No, for everybody but the two lawyers in the room. A Loudermill hearing is a due process requirement that gives some public employees a chance to respond to charges before disciplinary action is taken. That's all we're
It's
asking
not
for.
termination, a Loudermill could be for any discipline.
Before termination, disciplinary action is taken. It just gives the employee the right to take their case.
Yeah, I was thinking of something else, under Article 10, so we don't have it otherwise.
Would that be like more appropriate, like?
Yeah, again, I think we should just, the city will have to discuss
Yeah.
Yeah.
the proposal.
Okay.
No.
Should we caucus the proposal?
I don't know if we're gonna have time to really caucus and then be done by 4.
I can go beyond 4, I'm just gonna put it out there.
I can too.
I can't.
Yeah, I just talked to Jennifer about something personally.
Okay.
And we have to meet with, I'm sure, talk to the mayor, right?
Yeah, I can reach out to the mayor, he'll
Yeah.
respond.
Yes.
Oh, should we just stew until? next
Is there
Tuesday?
some articles that we could cross off from those 4 that?
Like it is.
He's reading that.
He's
Oh.
already know.
I'm the person that just always listens.
I mean,
I do too, I just
Okay.
want to try to order.
There a little convenient sign.
yeah,
There
there's a
is.
There is,
that
there's a
says
sign.
please.
Yeah, they're right there.
And
Oh,
it's
really?
really dark on the window.
Oh, yeah,
The tent is really dark, so it's hard to see. I think, isn't that your guys' intern?
No.
Oh.
No. No, but that
Their intern.
Maybe a laminated sign stuck to the outside.
Yeah.
I don't.
probably be taken off.
The entertainment.
I mean, it sounds like we are pretty much in agreement about Article 6. We just would draft language. To include what we discussed,
And run that by the, I
and
mean,
make sure the mayor.
make sure the mayor.
Well, we gotta run all of it by the mayor.
Sure.
first. And then we'll need to consider what you changed in Article 11 about sick and vacation.
But the other parts that you didn't change.
So otherwise you were accepting of our proposal for hours worked on holidays, other than taking out water and wastewater plants.
Yes.
You were in call outs on holidays. And then for discipline, you just wanted to add that,
Yeah.
and you're okay with Sundays being removed.
I wouldn't say we're okay.
Well, you begrudgingly accept it.
It's a concession.
Okay.
I mean, we won't know until we take it to the,
Yeah. Well, we don't know if council likes this either. Okay.
Okay.
So are we agreeing to be done then for the day?
I think we're okay on this side.
And then the city will review what we've proposed and we will submit a counter proposal
Prior to the next meeting.
prior to the next meeting. And it is 3:40.